A very good morning to all of you. May I request everyone to please close their eyes, just for a minute. Don't worry, it's not a meditation session. We are still at the Delhi arbitration weekend. Just close your eyes for a minute. Now imagine jumping out of a skydiving plane and discovering your parachute doesn't work. What memories would flash before you? Now imagine the parachute opened. How differently would you act when you landed? Well, the years 2020-21 was something like this for each one of us. We all thought our parachute won't work and this is it. But well, our parachutes opened just in time, I guess. And that's what gave us the pleasure of such an august gathering at the first ever Delhi arbitration weekend. Namaste everyone. Welcome to day 3 of Delhi arbitration weekend. I am Radhika Bishwajit Dubey and it's my honor and most privileged to be your Sutradhar, your host for today's program. They say an arbitration is as good as the arbitrator. The theme of this session is appointment of arbitrators, discussing the role of judiciary, institutions, and parties. Arbitrations, unlike court adjudication, is primarily a one-step adjudication, thus legal discourse on the process of appointment of arbitrator or right to appointment of an arbitrator cannot be a mere formality, but rather a decisive aspect that deserves an in-depth scrutiny. Through this session, the panel would discuss the role of judiciary, institutions, and parties in appointment of arbitrators. May I have the honor of the chair and the speakers of this session to please join us on stage. We have the pleasure of Honorable Mr. Justice Sanjiv Khanna as the chair for this session. Honorable Mr. Justice Khanna was elevated to the Supreme Court in 2019, and prior to his elevation, he served as permanent judge of the High Court of Delhi since 2006. After enrollment as an advocate with the Bar Council of Delhi, Justice Khanna began his practice in the district courts at Delhi. As an additional public prosecutor, he also argued a number of criminal cases in the Delhi High Court. He also had a long tenure as the senior standing counsel for the Income Tax Department in the Delhi High Court. In 2004, he was appointed as the standing counsel civil for the National Capital Territory of Delhi. With him, we welcome our esteemed speakers. Honorable Mr. Justice K.R. Shriram. Honorable Justice Shriram, a judge of the High Court of Bombay, was enrolled as an advocate with the Bar Council of Maharashtra and Goa in 1986. In 1997, he set up his own chamber and dealt in commercial matters with specialization in shipping and international trade, writ matters, and appeared before various fora, including the Honorable Supreme Court of India and other high courts of India before his elevation at the bench. Moving on to Ms. Leigh-Ann. Ms. Ann, a King's Counsel, held the appointment of Deputy High Court Judge from 2016 to 2022. She is also called to the bar of the Republic of Ireland. She was named Group Litigation and Consumer Silk of the Year 2022 by the Legal 500 and was nominated for Chambers and Partners Insurance Silk of the Year 2022. She works both domestically and internationally, including in Asia and the Caribbean. A fellow of Royal Statistical Society, she handles many cases involving heavy technical expert and statistical evidence. Our next panelist comes with almost 20 years of experience working in Hong Kong, Ms. Chiann. She also works in New York and London. Ms. Bao practices exclusively as an arbitrator and mediator and is a member of arbitration chambers. Ms. Bao is listed on the panel of major arbitration institutes and serves as tribunal chair, co-arbitrator, and sole arbitrator in both ad hoc and institutional arbitrations. She also serves as an emergency arbitrator. She is a fellow of the Chartered Institute of Arbitrators and is a CERD accredited mediator. With this, I request the chair to please take the discussion forward. Thank you.
Namaste and very good morning to everybody. I've had a long association with the Delhi International Arbitration Center and was a chairman for some time and member of the committee. We have really seen this center growing in terms of number of cases, yet maintained a very low profile. Now it's time that we come out openly and say what we have achieved. At the same time, when I look at the figures with regard to the total number of matters which are referred to arbitration, the figures are not very good. In fact, just about 1 to 1.5% of the total number of disputes in Delhi go to arbitration. I have the figures with regard to the National Capital Territory of Delhi because the Delhi Arbitration Center has those figures. As far as ad hoc arbitrations are concerned, there are no figures available. The data with regard to 2018, I've taken that as a year-based data because we don't really have the data as 2019, 2021 because of COVID. Shows that about 1 lakh civil suits were filed, more than 1 lakh civil suits were instituted in the subordinate courts, and 3,964 original side suits were instituted in the Delhi High Court. But barely 489 matters were referred to the Delhi High Court Delhi International Arbitration Center in the same year. By this addition of 489 matters, total number of matters which were pending before this institution rose to 2,378. The pendency in that year in the Delhi High Court as a civil suits is concerned was 12,384 and civil suits in the district courts was 90,089. Now, what are the reasons why arbitration is not accepted as a truly alternative to court adjudication? It's an issue which unfortunately is never addressed and taken note of. Even in this conference which we are having, we are not really addressing those issues. Why is why is arbitration not treated as better than court adjudication? Until unless we address this issue, India will not become arbitration-centric. I have, if you've gone through Vidyadhularia, referred to in that judgment number of apprehensions which the parties have with regard to arbitration. I'm just listing out some of them, not saying that they are absolutely correct, but this is the perception which the litigants have. The fact-finding process in arbitration is not equivalent to judicial fact-finding, which is far more comprehensive and in-depth. There is limited or lack of reasoning in the awards. Arbitrators enjoy and exercise extensive and unhindered powers and therefore are prone to making arbitrary and despotic decisions. Arbitration proceedings are usually private and confidential. Arbitrators are unfit to address issues arising from economic power, disparity, or social concerns. There is no appeal process in arbitration, which combined with unhindered powers of the arbitrators and limited review of an arbitral award in post-award court proceedings may have devastating and unpalatable consequences for the losing party. Business and industry, by adopting and compulsorily applying arbitration process, leaves the vulnerable and weaker section with little or no meaningful choice, but to accept arbitration. Few people realize and understand the importance of loss of their right to access the courts of law or public forum, which are impartial, just, and fair. Arbitration is expensive and costly in comparison to court adjudication. Having said so, one must realize that appointment of the arbitrator is the key to successful arbitration. As it has been said, and I quote, "The choice of person whose purpose the arbitral tribunal is vital and often the most decisive step in arbitration. It has been rightly been said that arbitration is only good as the arbitrator." Having said so, if one looks at the history of appointment of arbitrators in India, we had Section 8 and 20 in the old Arbitration Act 1940, which was a fairly detailed process in which court would go on to determine what matters are to be referred to arbitration. And the court, once it decides only X matters are referred to arbitration, the arbitrator could not even expand the scope of arbitration, the scope of the matters which were referred to. 1996 Act brought about a big change, and initially there were judgments of this court holding that the process of appointment of an arbitrator was a purely administrative act. It was not a judicial act. This was upheld even by constitutional bench decision in Rani construction. The law underwent a complete change with the decision in the case of Patel Engineering. Then the legislature intervened and incorporated Section 6A. Then we had the decision in the case of Diogo Figueroa, wherein it was said that only thing which the court is to examine is whether there was an arbitration agreement. Once it exists and nothing more, nothing will be gone into by the courts. Then came the amendments incorporating 5th, 6th, and the 7th schedule, and the move from ad hoc arbitrations to institutionalized arbitrations. 6A itself was deleted, but then fortunately the Supreme Court in the case of Mayawati clarified the status quo ante prior to enactment of 6A is not the law as of present. Then came the judgment in the Vidya Dhaloria's case, and now issues are arising from that judgment itself. The second aspect which arises as far as appointment of arbitrators relates to what is non-arbitrable and at what stage that question is to be decided. Who decides non-arbitrability? Does the court decide it at the stage of appointment of an arbitrator, or is it to be decided by the arbitrator itself? This is also with reference to the proceedings or civil suits which are instituted by the parties where an application under Section 8 are then filed. How do we resolve that controversy? That again was dealt with in Vidya Dhaloria, wherein we had made a very practical solution to the problem, and that was, at the stage of reference to arbitration, we'll cut off what is called the dead wood. For legitimate reasons and to prevent wastage of public and private resources, the court, while exercising judicial discretion to conduct, would conduct an intensive yet summary prima facie review while remaining conscious that it is to assist the arbitration procedure and not to usurp jurisdiction of an arbitral tribunal. While doing so, we must divide how much discretion the court is to exercise. First aspect is the existence of the arbitration agreement. There, normally, one should leave it to the arbitrator. Question of limitation, ex facie, etc., can be dealt with by the court, where ex facie, it's apparent somebody has raised a claim after 20 years, 10 years, you can throw him out. But when the question with regard to non-arbitrability comes up, then sometimes, not always, the court's interference may be required. That's happened when matters are pertaining to Consumer Protection Acts or actions in REM, etc. It is in this context that the decision of the Supreme Court in the case of Sukanya Holdings comes into picture, because it draws a distinction, says that in cases where the causes of action or the parties cannot be split, then the matter should not go to the arbitration. That was again examined and has been dealt with in several cases, including the case decision in the case of Chloro Controls India Private Limited, but the question with regard to the group companies has been now referred to a larger bench in the case of Cox and Kings Limited. Similarly, the issue which arose, one issue which arose, which has taken some decisions, is with regard to the stamping on the main agreement, when the agreement itself is a part of an adhesion contract or so and so. That again issue is now pending before a larger bench. The third issue which arises is, first is arbitration agreement, non-arbitrability. Third issue which arises is with regard to the neutrality of arbitrators. We have had decisions right from earlier under the 1940 Act giving primacy to party autonomy as the determinative factor. If you clearly choose appointment of an arbitrator, even by one party unilateral reference, it does not matter. There was thereafter, after the 5th, 6th, and 6th schedule were introduced, there have been some shift in the reasoning given by the different judgments of the Supreme Court, which will be probably referred to during the course of the conference. I'm not going to take you through all of them, but the matter is still not fairly fluid. I will not say it's finally determined. Another issue which arises today, which probably is not being addressed, forget about neutrality of arbitrator appointment process. There have been some discussion abroad now on the question of party affiliation or nomination affiliation. And that's a matter of concern. There are some studies which have revealed that there is affiliation bias in the arbitrators. The party who nominates the arbitrator tend to support the case of that party. And it is not that it is apparent to the arbitrator, it is hidden to the arbitrator. He doesn't even perceive and know that he's doing it. And if one looks at the awards which are coming where there are 3 panel arbitrators, it is quite revealing. But as for now, I'll just refer to one study of 2017, a survey published by the University of Chicago. It was found in the field of arbitration, frequent use of party-nominated appointed arbitrators is likely to result in litigant-induced bias. Being appointed by one of the parties directly changes the behavior of the arbitrators, and the appointment itself is the cause of some bias of the arbitrator towards the appointing party. Some jurists have suggested what is called the procedure of blind appointment, that is not disclosing appointing parties to the arbitrator. I don't know whether it's feasible, whether it's workable or not. I'm not very certain. But these are issues which must be taken forward. Some thought process has to go into it, and some of us have to critically examine this aspect. Can I now ask my panelists over here to carry on from what I have said and enlighten us with their views on the issues in question?
Thank you, Justice Khanna. It's a privilege to be asked to speak on this illustrious panel and a pleasure to be back in Delhi after a long interval due to COVID. We're going to address the role of the various stakeholders in appointments of arbitrators, but to do so in reverse order to our titles. So I'm going to address the role of parties in making appointments, and then Ms. Bao will address the role of institutions, and Justice Shriram will deal with the role of the judiciary. I'm going to start with a point of principle relating to party autonomy and party appointment, which is, should parties be able to appoint arbitrators at all? The ability of parties to appoint their arbitral tribunal is probably the most widely accepted norm of arbitration. It's a central characteristic of party autonomy, either to be able to choose an arbitrator or the method of appointment. It's reflected in the institutional rules. It's also reflected in the Indian Arbitration and Conciliation Act, which all provide for party appointment of arbitrators. It's been rated as the fourth most valuable characteristic in the Queen Mary University of London survey in 2018, which was looking at the evolution of international arbitration. And the reasons for that are said to be that it gives parties a sense of control, a sense of proximity to the proceedings that engenders confidence in both the process and the outcome, and also that they're best placed to choose the right individuals for the specific dispute, taking account of differences in culture, legal origin, etc. And nearly 70% of respondents to the Berwin-Leighton-Paisner survey in 2017 on party-appointed arbitrators were of this view. Now, the practice of party appointment is so well established that it might seem almost heretical to even ask the question of whether parties should be able to appoint arbitrators. But nonetheless, there is a tension between party autonomy in this regard and the need for independence and impartiality and the non-biases which are at the core of all forms of adjudication, whether in court or in arbitration, and which are essential to ensure trust and credence in the process. And it's becoming all the more important for arbitration because it is increasingly becoming a one-stop form of adjudication, with parties either signing up to institutional rules or agreeing to waive their rights to appeal and potentially to challenge an award. So if you have only one shot at it, who you appoint is absolutely crucial. And it is therefore important to have a conversation about party appointments and to discuss whether, and if so, how the tension between party autonomy and procedural justice can be managed. So what is the objective of parties appointing arbitrators? I think it's encapsulated openly and very frankly by Paul Friedland of White and Case in an article he wrote in 2019 about selecting party-appointed arbitrators. And he said this: the objective of any party facing the selection of a party-appointed arbitrator is to maximize its chances of winning. The ideal party-appointed arbitrator is an individual who, once convinced of the merit of the positions advanced by the appointing party, will be motivated and able to convince the presiding arbitrator and the other party-appointed arbitrator of this point of view. But this begs the question, how does that square with principles of procedural justice? And that objective and the practice of parties appointing arbitrators has been questioned. It's been described by Professor Paulson as a moral hazard and by the late Professor Schmidt as the reality being that many, if not most, party-appointed arbitrators respond to their personal incentives and become, to a certain extent, party advocates within a system that expects them to behave objectively. And there is statistical and survey evidence that provides some support for a concern that there is an issue over party-appointed arbitrators not necessarily behaving in a way that is treating both parties equally and is independent and impartial. And Chief Justice Sundaresh Menon of Singapore has written two powerful critiques. The first in 2016 entitled Adjudicator Advocate or Something in Between, and another in 2021 about arbitration's blade and arbitration being an attenuated form of the rule of law, raising concerns in particular about party appointment of arbitrators and about parties' expectations of the arbitrator that they have appointed and the conduct of party-appointed arbitrators as being inherently biased because of the economic incentive for the appointee to be sympathetic to the appointer's case, and for this to be potentially at odds with the rule of law. Now, it seems very unlikely that such a long-established practice will be jettisoned, but it is important to be aware of the need to harmonize appointment procedures with non-derogable principles of independence and impartiality, which are essential for parties, and in particular the losing party, to feel that they have had procedural fairness. And I think it's relevant to keep these concerns in mind and that tension when it comes to looking at the issue of how do you appoint arbitrators, what is the method of appointment, and I'm going to turn to that in a moment, and also the issue of unequal appointment rights, which I will address last. Before I do, just to mention that the BLP survey also looked at options to address the criticisms. So whilst recognising the overwhelming majority did not wish to give up party appointment of arbitrators, they were asked for views on what might be the alternatives. And the use of the list procedure by the institution or appointing authority was the most popular, conferring as it does some form of party input into the process of appointment. It's usually done with the ability to strike a candidate from the list and to rank others, whereas appointment done without any consultation by an institution from a pre-existing closed list was the least popular. I'm going to turn now to the mechanics of party arbitrator appointment, and briefly to look at the issue of the number of arbitrators. It's usually an uneven number, to avoid a tied result, and the practice historically of appointing, and in specialist fields, of appointing 2 arbitrators and then having an umpire if they disagree is increasingly uncommon. The choice for international commercial arbitrations is usually either 1 or 3. Parties can choose in their arbitration agreement. The default is usually 1, and that's the position in India, England and Wales, Australia, Singapore. But under the UNCITRAL rules, it's 3. The default is 3, and they are adopted in Japan, Korea, Germany, and China. So it does vary. Obviously, the advantages of a sole arbitrator is that the process tends to be quicker. It's certainly cheaper and can be more agile, but it's much more difficult to get parties to agree on a joint appointment. And if they do agree on somebody, that person may not be available to hear the dispute. The advantages of a tribunal of 3 is that it allows each party to nominate. So the tribunal can reflect the geographical, legal, linguistic traditions across the parties, and there is less risk of an error of law because you've got balance being brought by having 2 further arbitrators. It's not all falling on the foibles or failings of one arbitrator, which can potentially be the case. Turning to the method of appointment, it's usually it is specified in the arbitration agreement, but not if it's an ad hoc arbitration. The parties then need to agree how to proceed to appoint, in default of which a national court will decide. Where there's more than one arbitrator, parties usually nominate 1 each, with the chair either being appointed by the co-arbitrators or by the arbitral institution or by a national court, or using a list procedure. Institutions retain the right to confirm a nomination by parties, and in some cases they have a power to appoint all. For example, if there would be a significant risk of unequal treatment or unfairness that could affect the validity of the award. And in recent years, the institutional rules have adapted to deal with issues over multi-party arbitrations, which are now specifically dealt with in the rules, with each side, where there are multiple parties on a side, jointly appointing an arbitrator, and if they can't agree, the institute appointing. Choice of arbitrator. Now, the selection of an arbitrator, as has been said, is a pivotal decision. It can be decisive of the outcome of the whole dispute. And there are clearly a number of factors to consider. Applicable law, civil law, common law expertise needed. Is it a legal dispute that's going to turn on interpretation of legal principles or construction of a contract, or does it turn on the facts? Is technical expertise required? What is absolutely essential, as we've, I hope, already seen, is independence and impartiality, because without it, it can lead to the removal of an arbitrator or the challenge to an award. So there is no point in trying as a party to appoint an advocate. They have to be somebody who will generate the confidence that they are independent and impartial. In international arbitration, where parties are of different nationalities, there is a need for neutrality, where there is a sole arbitrator or for the chair. In India, as I understand it, the Act is permissive on that front, but the Supreme Court has emphasized the importance of neutrality in the Voestalpine case. More prosaic, but nonetheless very important matters are things like availability. There are arbitrators who overtrade, and it inevitably leads to delays in arranging hearings and in writing awards. So if you are looking to appoint a potential nominee, do ask about their availability, and not simply in general terms, but ask specific questions about their commitments during the relevant period so that you find somebody who has the time to devote to the arbitral dispute. It's worth also seeking to appoint somebody who's motivated, who's industrious, who's organized, who's efficient. There can be a real advantage in appointing younger arbitrators who are trying to make their name, who are hungrier and who are therefore more likely to devote time, do a good job, deal with things quickly. So it's another factor to bear in mind. And I would respectfully suggest you would also want to be appointing somebody who is proactive as sole arbitrator or as chair, not somebody who is unwilling to alienate the parties for fear of not being reappointed, or who's very laissez-faire. It's trying to find somebody who won't indulge bad behavior or dragging of feet by a party. It starts to get very frustrating and very expensive if an arbitrator doesn't case manage properly or allows an acrimonious correspondence war to develop, which won't assist the decision-making, but becomes incredibly time-consuming and expensive for the parties. And I would stress that having somebody proactive and strong-minded isn't incompatible with the consensual and inclusive approach to arbitration, or being collegiate, or respecting cultural differences. But it is something to bear in mind. And then finally, experience. It's regarded as important, so that, in particular for a sole arbitrator or a chair, so they can operate the process properly and carry weight. But it's just also worth bearing in mind, as I contributed in a session yesterday, that must not become a barrier to appointing more diverse arbitrators. It's very easy to rely on experience as the reason to go to the same people over and over again. Which can give rise then to issues of overtrading and groupthink and overdependence on certain arbitrators, giving rise to issues of perceived bias. I'm going to turn now to my final issue, which is unequal appointment rights. And this is an issue that it's interesting to discuss, because India would appear to be towards the forefront, or at the forefront, of thinking on this. And this is the unilateral appointment of a sole arbitrator by one party. There's clearly an obvious tension there between party autonomy and the need to respect what the parties have agreed to on the one hand, and issues of procedural justice on the other. And I understand it's not uncommon in India to have such a provision in contracts, either involving the government as one party, or in standard form contracts that are not, or standard format contracts that are not negotiated. And in the case of Perkins Eastman, the Indian Supreme Court held that even if that is the provision in the contract, the choice of one party will always have an element of exclusivity in determining or charting the course for dispute resolution, and that wouldn't comply with the 1996 Act. So in that case, procedural justice prevailed over party autonomy. I gather that this is to be considered by a larger bench. So we all watch this space to see where Indian law goes on this. I'll just go back one. There was an interesting decision about the same time as Perkins in Canada by the Supreme Court there. Now, it's not about unilateral appointment, but it's about whether party autonomy in an agreement for mandatory arbitration was capable of being superseded. It was a class action involving a mobile phone company with allegations of overtrading, and there was a standard form contract entered into with both for personal use and also for business use, so consumers and non-consumers. And the consumers had the benefit of the Canadian Consumer Protection Act, and they could insist on their claims going to court. The non-consumers could not. And in a closely split court, it was split 5-9, it was held that party autonomy did not prevail. The claims of consumers and non-consumers were not separable under the relevant Arbitration Act. and accordingly they should all proceed via litigation and not via arbitration in the case of the non-consumers. And what's interesting is that it directly raises this issue over inequality of bargaining power in the context, and it underlies the tension between party autonomy and procedural justice. And applying those principles in Vijaya, Drolia, and Durga, which Justice Khanna mentioned, in which he was one of the judges, it was held by the Indian Supreme Court that while interpreting an arbitration clause, you can have a broader interpretation where the clause is being between commercial parties, and a narrower interpretation where it's being sought to be imposed on a layman or somebody who's not fully aware of the effect of the clause or had little option but to sign the standard form agreement. So it will be interesting to see how that concept of inequality of bargaining power develops and in the debate about party autonomy. In my own jurisdiction, on unilateral appointment, returning to that, party autonomy still prevails, and that is the Sumakan case from 2009, where it was held if one party agreed to unilateral appointment, they're taken to have waived any objection. The position will be different following the Consumer Rights Act 2015 in relation to consumers. It doesn't seem to have been such an issue in England and Wales. That may be because parties are not seeking to unilaterally appoint arbitrators there, or possibly there may be slightly less inequality of bargaining power, but it's not been such a developing area in my jurisdiction. Finally, I'm just going to mention panel appointment on the same topic of unequal appointment rights. A different position might apply where the appointment of one party is appointing a panel, and then the arbitrator has to be chosen from that panel. And in India, the Supreme Court appears to have accepted that that's not incompatible with the principles of independence and impartiality, provided the panel is broad-based and is available to both parties so that the other party has a say. There's an interesting parallel with a recent decision of the English High Court, where Manchester City Football Club sought to challenge the appointment of 3 KCs as arbitrators from a panel that was maintained by the Football Association Premier League. And it was on the grounds that the appointment by one party of the panel from which the arbitrators had to be appointed was incompatible with the principles of procedural justice. Now, that challenge was unsuccessful, despite the lack of an open appointments process or a written selection policy. Relevant factors for saying that it wasn't incompatible with procedural justice were the fact the club had some, albeit a small, say in the appointment of the panel. And the 3 KCs who were appointed were eminent practitioners in independent practice at the bar. They weren't dependent on their appointments via the Premier League panel for their living. What was interesting is following the challenge, but before the decision, the Premier League actually changed to a wider panel, and it ceased to nominate to that panel. So the challenge itself seems to have produced a result, but it wasn't held that the appointments were in any, caused any problems. So it looks like an area for potential development. How far can one party create the pool from which an arbitrator has to be drawn? And in areas where there is some kind of expert panel requiring a particular form of expertise, where there may be a smaller pool, it's going to be important to look at issues of potential affiliation bias. So how did the arbitrator acquire expertise? Have they worked for the side of one party? For example, retired public servants might be an area which would be subject to further consideration. It's worth bearing in mind issues over unequal appointment rights could render enforcement more difficult in certain jurisdictions because of the principle of equality. So I'm going to hand over now to Justice Khanna again. Thank you.
I think that was very well presented, the different viewpoints, highlighting the tension and the conflict between party and autonomy, and sometimes the procedural independence. This is not an easy topic. It's been debated in India, it's been debated abroad, and it has various contours. right from selection from a panel, unequal bargaining power, standard format agreements or take it or leave it contracts. Can we have somebody who has a view on this point and his own experience, if somebody has his own experience on this point, to join in and say something? Okay, tell me, how many of you feel there is an affiliation bias in arbitrators? And how do you think, I guess the others either are no-sayers or they don't feel there is affiliation bias. How many of you feel that there is no affiliation bias? Very few, most of us are either neutral or feel there is affiliation bias. And I guess most of you have been associated with arbitration. Now, how do you think that can be best tackled? Yes, please.
Affiliation bias in a three-member diverse panel may not entirely be sort of fatal to the neutrality or the procedural fairness of the hearing. But where I have seen affiliation bias is repeat reappointments of same arbitrators in where one of the parties is common. And in such a case where there are sole arbitrators, those may lead to, that kind of affiliation bias leads to sort of fatal outcomes in terms of procedural fairness. So when you have a three-member panel with more scrutiny on the neutrality of the umpire or the third member so appointed, I think the requirement of procedural bias sort of gets met. But that also requires more intense sort of institutional rules and procedures, and that's something that institutional arbitration is likely to remove. But what I'm more concerned about is repeat appointments of a sole arbitrator involving the same party in multiple arbitrations. Often courts tend to do that because the courts feel that there are similar disputes already being adjudicated by one person and therefore he may be better equipped. But in my experience, you lead to a lot more sort of procedurally unfair outcomes. But it's difficult to lay down a yardstick on how many repeat appointments is it to make an arbitrator ineligible or unsuitable for a particular subsequent arbitration. So that's something that's we should sort of have an objective criteria on.
Can I just put in, I think what he has raised is a very important point. He has said, one, if there are three-member tribunal, normally that's somewhat curtailed or checked. Two, he has said is that institutionalized arbitration is another check. But the biggest take from his what has been said is repeat appointments is an issue which affects the arbitration. So repeat appointments, how it is to be checked, where it is to be checked, what is the threshold, is something which requires a little more debate and understanding.
Good morning.
Can you please also give your name?
My name is Renu Gupta. I'm an advocate. I don't have a solution, but a suggestion that I saw in a case which is being talked about. Yes, yeah. There was an award which was set aside by the Paris Court of Appeal, and the situation was a eulogy written by Thomas Clay, who was the presiding arbitrator for Emmanuel Gaylord, who was a lawyer for one of the parties. The award, Mr. Gaylord, passed away, and the tribunal had passed an award. Now, when it came up for a challenge, the point was that the eulogy shows a very personal, close relationship between the counsel and the arbitrator, and at what stage should this disclosure have been made? The Paris Court of Appeal says that this disclosure ought to have been made at the very beginning, and the failure to do that has to mean that the award has to be set aside. So I think that's one suggestion. Very extreme, but somewhere around that. Thank you.
just to respond to that, it's been very interesting in the UK to see the effect of the Halliburton and Chubb decision, which related to Bermuda form arbitration, a very narrow pool of arbitrators, and an arbitrator who had ended up being appointed in several arbitrations involving a common party, but without disclosure having been made. And ultimately, the decision not to remove the arbitrator was upheld by the Supreme Court in December 2020. But the disclosure obligations, which weren't certain in English law, have been strengthened as a result. And my experience is that arbitrators are now disclosing practically everything. I mean, going well beyond the IBA rules, which I know are also incorporated in India. And I think that's helping with transparency, because it's far better to have that disclosure at the outset, and if there is an issue, for it to be dealt with then, than to come at the end. But there is certainly an issue with repeat appointments. They're being catered for by the IBA rules because there are limits on how many can be made, but there is still a potential issue with smaller pools. And I know Justice Shriram is going to talk about maritime arbitration, which is an exception to that rule about only being able to have a certain number of appointments within a period before you're appointed to a particular arbitration.
This problem what was raised now about repeat appointments has been factored in under Section 12(1)(b), the explanation that is given, and that raises when they are referring to Schedule 5, where circumstances exist which gives rise to justifiable doubts as to the independence or impartiality. The Schedule 5 report refers to more than 3 appointments. So these are factors. So if somebody refers in the name of a particular arbitrator, and if you are aware of that person having been appointed repeatedly earlier, then certainly you can object and then suggest some other name. And if the person still goes under a Section 11 application to the court, this can be brought out to the notice of the court, and the court will certainly weigh and consider whether there could be an element of impartiality. So this is being taken care, and courts are aware, and the courts do take care of that.
Yeah, actually, I was this Prashanto Sen, senior advocate. I was just about to go to that explanation to talk about those specialized arbitrations which are there. But one more thing about affiliation in party-appointed arbitrator. In US, it is accepted, and though they are trying to move away perhaps, is that there is going to be a bias, and that is to be accepted as a fact that yes, the party-appointed arbitrator, there is going to be a certain batting which takes place on behalf of the party, and it's left to the presiding arbitrator. And I think we have to accept that reality and live with it, because otherwise there's going to be alienation from the arbitration by the parties themselves, because they have advocates, but they also need to have that sense. That's the attraction of arbitration, especially in domestic arbitrations here, that their person is also there on the tribunal. So I think a 3-member tribunal with a presiding arbitrator to control may be better. There is some merit in saying that once an arbitrator is appointed by a party, he develops some level of independence once he's in the tribunal, because there is interactions going on. But that's a very gray area. It depends from person to person. So I think one has to accept that reality and hope and try to make sure that the presiding arbitrator.
It's easy for an advocate to say that, but put yourself in the shoes of the client and the litigant, and you know how it hurts sometimes. Yes, I think Schedule 5, right, with the amendments made in 2015, bringing into Schedule 6 and 7, have been a game changer. And I'm not very sure how it's working at the ground level, to what extent it's actually working. Institutionalized arbitration certainly helps, because then you have to select, or somebody is appointed from the institute itself. And it does work well. It does work well. I've seen very good awards coming in the Delhi International Arbitration Centers also. But these are very positive steps. These are certain very positive steps, legislative steps. We have to now bring them into, when we implement them, how effectively we are implementing them in the course of arbitration and also in our decisions in the court. The issue also comes up at what stage do we interfere in such cases, whether after the award or before the award. That's been also addressed in some decisions. I think somebody, out of us will be later on talking about it. It's been addressed in some decisions. Anybody else who wants to speak on this?
My name is Chiann from Singapore. I just want to add on to what the earlier speaker said. It is true that the practice and culture is that the party-appointed arbitrator feels that he needs to advance the case of the party appointing him. In fact, the commercial party expects that too. But this is a classic case where culture and practice becomes the law, and the question is whether the law should reset culture and tradition. I like the suggestion of Justice Khanna in saying that there's a suggestion that party-appointed nominee should not be told. Of course, if that can be kept a secret from the party-appointed arbitrator, and he starts the arbitration declaring that he doesn't know, that would help. But because of this problem of party-affiliated bias, you can see that there's a reason why Justice Sundaresh Menon of Singapore suggested to have commercial courts, because the essence of a court is that the judge is completely independent and he's not paid by the parties. He's not suggested to be nominated by the parties. But the fact that when an arbitrator is appointed by the party and he's paid by the party, there is a natural bias. So the question is whether the arbitration community has the strength to face this issue head on to change a culture.
It's a very valid point made. The other way to look around is that none of the parties appoint an arbitrator. There's a single member arbitration tribunal, but the drawback in that is that party autonomy principle is affected. That's again an issue. So probably some solution with passage of time has to be found. But as long as we understand there is an issue, then only we can address it.
Thank you very much for this.
Your Lordship, if I may, I am Colonel Bishnoi and I am coming from Mumbai. I can come forward in case I am not audible, sir. Are you only to see me, sir? Justice Shriram has been seeing me in Mumbai. Sir, I am Colonel Bishnoi. I am practicing in Bombay High Court. And I am a fellow of Chartered Institute of London and member of Singapore Institute of Arbitrators, and also fellow of Australian and New Zealand arbitral institutions. Sir, it is a pertinent point. Let me first thank the DIAC for organizing such a brilliant program, and Venu and the topic and the elite panel. And also thank the chair that it was made interactive by throwing the issue to the House. Now, I have an experience without naming. It's not a complaint, it's not a grudge, it's sharing because it's a topic that is being discussed. There was a case in which an arbitrator was to be appointed, and one party gives out a name for appointment. That name is shelved, the proceedings are adjourned. On another occasion, the another party comes out with a panel of 5 arbitrators. So the interesting fact is one of the arbitrators from that panel that one party brings out is selected. The other party says that ask me also for a panel. So the issue is that when we go for the panel, so the issue arises that his panel and my panel.
Mr. I'm sorry to intervene. Could you keep your question a little crisp so that...
Finished, ma'am, finished. Question is finished. It was not a question, ma'am. It was just sharing of an experience. Thank you so much. I'm so grateful.
Certainly. Thank you very much. And thank you for that lively discussion. I think it certainly sets the scene from the party's perspective as to the importance, but also the cautionary tales of the appointment process. What I wish to bring to you today is the institutional perspective. Now, as Leigh-Ann had indicated, certainly the party autonomy is the trump card for this process. However, there are instances where parties cannot agree. And so I wish to take you down a journey where parties cannot agree in an ad hoc setting. I take the institutional approach, but I wish to take you down a more organic path. And that is if a party in an ad hoc arbitration has an arbitration seated in, I will take the comparative approach of 4 different jurisdictions: India, Delhi, London, Hong Kong, and Singapore. And so what I wish to present to you today is the journey of a party who has this arbitration. There is an arbitration agreement for the present purposes. There is a good arguable case for a valid arbitration agreement, and the party has a seat in India. I say Delhi because we are here, but frankly, you will know much more about the Delhi situation than I will. But what I can give you and offer you is some statistics from the Bombay High Court. There was a study done by the Arbitrators dossier, whereby there was a study done on the appointment of arbitrators statistics between 2019 and 2011, whereby there were, out of 143 applications, 100 appointments made. Sole arbitrators appointed were in 95 cases, and 3 arbitrator tribunal constituted in 5 cases where the identity of the 3rd arbitrator was not stipulated. Of these appointments made, 33% were retired judges, 61% were advocates, and the remaining were senior advocates. And of these appointments made, 81% were male and 19% were female. In terms of the number of days that it took to make this appointment, it is over almost 40% of them were made within 1 month. However, of the remaining 60%, that took over 2 months, with 42% taking over 3 months to make the appointment, and over 30% taking more than 4 months. So this is just a landscape as to the expectation of a party engaged in an ad hoc arbitration seated in Mumbai, if they took their undecided arbitration to court, undecided appointment to court, the kind of length of time and the expectation that one might have in engaging the court for an appointment of an arbitrator. Now, you will know much better than I will in terms of how that journey continues. What I wish to share with you in more detail are the remaining jurisdictions. Now, say you have an arbitration and you are seated in London. The UK Arbitration Act deviates from the UNCITRAL model law, but it still stipulates that the appointing authority shall be the UK. Now, from my friends in the UK, I understand that this is very rarely used, and in fact, generally used under Bermuda forum contracts. And so the courts are not regularly engaged in ad hoc arbitrations whereby the court will actually be asked to execute on its function of making an appointment of an arbitrator. And so where I wish to focus then is on Singapore and Hong Kong, much closer to home, but in fact carry a very similar path as to having the UNCITRAL model law serve as its legislative framework, whereby both jurisdictions have expressly legislatively stipulated that the institution shall play the role of the appointing authority rather than the courts, which is a specific deviation from the UNCITRAL Model Law, Section 11. Now, in doing so, and I will take Hong Kong as the first example, because in Hong Kong, much like in India, traditionally ad hoc arbitrations were the norm. Only in 2008 did HKIAC establish a set of institutional rules. And so institutional arbitration has only been in existence in Hong Kong for 2022 minus 2008. Now, in Hong Kong, the way in which the HKIAC executes on its appointing authority functions from a legislative perspective is that, in fact, under the arbitration ordinance, you have, so the party comes to the party has an arbitration agreement stipulates Hong Kong as the seat of arbitration. Where does one go if the parties can't agree as to who the arbitrator, generally the sole or the third arbitrator, shall be? In this case, under the arbitration ordinance, there is subsidiary legislation that sets out a set of arbitrator appointment rules. And under this set of rules within the legislation, there is a set of rules that sets out the framework for when parties cannot decide on an arbitrator, the appointment of an arbitrator in an otherwise ad hoc arbitration. And under these set of rules, what happens is that there is an arbitrator advisory body that's set up. It's called an arbitrator advisory board. And who is comprised in this board? Individuals such as the Chief Justice of the Hong Kong Court, the President of the Bar Association, the President of the Law Society, industry individuals such as the Hong Kong Corporate Counsel Association, and other industry bodies that comprise of this board, which HKIAC must consult 3 members of in order to execute on its appointment function. And so this set of rules sets out the framework where there is a subsidiary body that keeps a check on the HKIAC appointments. And furthermore, under these set of rules, there are appendices whereby parties have to fill out forms such that are legislatively approved and appended within the main body of the arbitration legislation, such that parties will go directly to the institution, foregoing the court, because the appointing authority, of course, is the HKIAC itself. And so parties who have an arbitration seated in Hong Kong, who cannot decide on who the arbitrators will be, will then go to HKIAC directly and fill in a form, pay the fees as stipulated in the arbitration legislation. And so, in fact, in the arbitration legislation, it states that the application fee is approximately 8,000 Hong Kong dollars, 1,000 US dollars. And the HKIAC then takes this appointment on and executes the appointment process in the way it would do for any institutional arbitration that came under the HKIAC. So you see the mechanics of the arbitration agreement and the failure to approve or failure to agree on the arbitrator. It takes the path directly to the institution, which has a delegated power and function to make these appointments. And furthermore, once this appointment is made, then it is confirmed by the proceedings committee within the HKIAC, which serves as a parallel to a court of an arbitration, as you might be more familiar with under SEAC rules or ICC rules. And so that's how an arbitration appointment is made in an ad hoc arbitration in Hong Kong. We then look at if one party has an arbitration seated in Singapore. This ad hoc arbitration, again, goes directly to SEAC. Under the arbitration legislation, the Arbitration Act in Singapore, the parties will go directly to SEAC because the arbitration legislation expressly stipulates that the president of SEAC will be the appointing authority, which is slight nuance from Hong Kong, which says HKIAC as a body. Now, that nuance is only in name, really not so much in function, because the reality is that the president of the SEAC will take its court and the operating body of SEAC to make the appointment. And so I wanted to take you through the different avenues by which you have an ad hoc arbitration seated in these various jurisdictions. Now, here is my institutional pitch, because I wear the institution hat on this panel. Now, why would one go to the institution versus any other body, specifically in this case, a court? For argument's sake, there are four main public policy reasons why one might go to the institution. And this addresses some of the issues that were raised during the discussion, and also Chief Justice Khanna had raised in terms of cautionary issues that might arise when the party is engaged with the appointment process. Now, why would one might one go to the institution? There are four main public policy reasons. The first one being the institution's main role in the arbitral framework is to make appointments, and most important role is to make the appointments. So they regularly engage in the process of making appointments and have structures and frameworks set up to make appointments on a regular, in fact, daily basis. And what this allows then to address the statistics raised in that I mentioned in the Bombay High Courts is that what this means is that they can make these decisions efficiently. They have a panel of arbitrators, and they are readily equipped internally to make appointments within 24 hours, as they do in emergency arbitrator situations, or in 2 weeks is probably generally the outlying figure for making appointments because of the consultation period, whereby parties still have an opportunity to comment on any appointment that the institution makes. And so the frequency and the structure of that is one primary reason where institutions may be a better fit for making this type of, serving out this function. Another reason is transparency. Certainly all institutions have some form of panel, whether it be an express and public panel, or whether it be like the ICC, where online you can see who is being appointed on a regular basis. And these names are readily available to the public to know who is sitting in ICC cases. And so the transparency of that allows for, again, the legitimacy of the system, whereby parties know exactly who the arbitrators are, who they are available, and also have an opportunity to comment as well. The third public policy reason is that of diversity. This has been mentioned time and time again through the panel sessions and also in our opening session a few days ago, whereby the issue as to diversity, not only in gender, but in particular in ethnicity and in first-time appointments and a broader range of industries represented within the appointment, within the available body of arbitrators is a very important aspect to consider as well. Certainly in this day and age, parties themselves, the clients themselves, demand on their counsel and demand on arbitrators to be diverse. And this can be not just a diversity of in whatever context we're talking about. So of course diversity is relative. We sit in this forum where diversity means something very different than a forum in Hong Kong or in New York or in London. And so diversity is very important for the sake of, again, what the demands are of the users who are engaged in arbitration. And finally, my final public policy point in relation to the plight for institutional arbitration is that in India, we have many arbitrations around the world now involving Indian parties. Certainly we see this at the ICC, where one of the top 10 users of ICC arbitration year on year is now in Indian parties. So the number of Indian parties engaged in institutional arbitration around the world will only increase. And what does this mean for the appointment of arbitrator function? This means we need more Indian arbitrators. And how does institutional arbitration allow for more Indian arbitrators? Because locally, institutions have the depth to understand the talent on the ground and give new arbitrators, their first opportunity to engage in arbitration as an arbitrator. So this first opportunity for local arbitrations, ad hoc arbitrations seated in Delhi, seated in Mumbai, allows for arbitrators to engage in the role, or for practitioners to engage in the role as an arbitrator and get that first-time experience, such that when there are arbitrations around the world involving Indian parties, institutions like the ICC, SIAC, HKIC can then draw on better-known names with experience to represent Indian parties in international arbitration. And so there are 4 main points in terms of public policy why one might consider the institutional approach when making appointments. Thank you.
Due to paucity of time, I'm going to request Justice Shriram, and then if there's time permitting, we'll go through. But just 2 comments or 3 comments I want to make. It's been rightly pointed out that institutional arbitration has its pluses over ad hoc arbitration. Legitimacy and credibility is to a large extent established in institutional arbitration. The other point made with regard to diversity, if somebody wants to have that report, is 2013 report, which is available on the net. It does accept that as far as arbitrators is concerned, it's virtually taken over by the legal community. There's lack of domain expertise coming to industry specific is concerned. That's an area of concern, and I think that concern also should be a matter of concern, including to the Delhi International Arbitration Center. The other last comment is this unfortunate state of affairs. If it's said that top 10 losing parties year after year in international arbitrations are Indian parties, is something a matter of concern. We must look into it. Can I ask Justice Shriram?
Thank you, Justice Khanna. Good morning, everybody. What I'm going to say, there is going to be a bit of an overlap. Justice Khanna has covered it in this introductory talk, Ms. Mulcahy and also Ms. Chiann. As regards the role of the parties, most important aspect is the element of mutuality. And there can be no unilateral appointment, and the arbitral tribunal has to be appointed by with the consent of the opposing party. So this was one of the most important cases in which this came up for this consideration was Perkins Eastman Architects DPC versus HCC India Limited, where from what it came out is while drafting an arbitration agreement, one should keep in mind the law as laid down by the said judgment. The court held that an arbitration clause providing for an officer or a representative of one of the parties to act as the arbitrator is ineligible. That takes care of what you mentioned and also the doubts which was raised by some of the participants here. And further, there also cannot be a case where only one party has a right to appoint a sole arbitrator, as its choice will always have an element of exclusivity in determining or charting the course for dispute resolution. The person who has an interest in the outcome or decision of the dispute must not have the power to appoint a sole arbitrator. This was also followed by the Bombay High Court later in Light Bite Foods Private Limited versus the Airport Authority of India. Then comes the role of the judiciary in this, which is one of the main things everyone is looking up to the panel. The role of the judiciary, as far as I would say, has been very, very diverse. The judiciary plays diverse roles in the arbitral process, from assisting, supporting, to supervising the arbitral proceedings. In the event of a deadlock, the party's only recourse is to approach the High Court or Supreme Court under Section 11 of the Act. Typically, this includes, which is a major problem that we have faced, why people have to approach the court, is failure to prescribe a procedure for the appointment of arbitrators, or failure to adhere to the procedure prescribed under the arbitration agreement, or failure to reach consensus on such appointment. Then the existence of an arbitration agreement, how far should the court go into? The Supreme Court, as the case may be, or the High Court, while considering an application, shall, notwithstanding any judgment, decree, or order of any court, confined to the examination of the existence of an arbitration agreement. This was section 11(6)(a), which Justice Khanna mentioned, was inserted by the Amendment Act of 2015 and was later deleted in 2019. But of course, the deletion has not altered the purport of section 11(6)(a). The Supreme Court, in case of Duro Felguera, held that Amendment Act of 2015 and the insertion of 11(6)(a), the role of judiciary is restricted to only see whether the arbitration exists and nothing more. But then later, Vidya, one point of which has been referred to a constitution bench. Otherwise, also where Justice Khanna had authored that judgment, so they reiterated the limited scope of interference by the judiciary at the stage of appointment of arbitrators in an application under Section 11, and the examination of existence of an arbitration agreement is intertwined with an examination of the validity of an arbitration agreement. And as such, the examination as to the existence of an arbitration agreement would mean to examine whether the arbitration agreement meets and satisfies the statutory requirements of both the Indian Contract Act and the Arbitration and Conciliation Act. For Justice Ramana, as he then was, by his supplementing judgment, held the scope should be to only on the determination of three questions: whether the agreement was in writing, whether the agreement contained in exchange of letters of telecommunications, or whether the core contractual ingredients where the arbitration agreement were fulfilled. On rare occasions, whether the subject matter of the dispute is arbitrable. And it was also clarified that the judiciary was empowered to interfere at the Section 11 stage only in circumstances when it is manifestly and expressly certain that the arbitration agreement is non-existent, invalid, or the disputes are non-arbitrable. Then in Vidya, the court was attempting to narrow the scope of inquiry and applications under Section 11. I wouldn't go into the sufficiency of stamping, because that's subject matter of reference to a constitutional bench. And that basically takes care of how much is the judicial intervention that is required. Then the issue also came before the courts whether certain disputes were arbitrable. The Apex Court in Booz Allen Hamilton, which is a 2011 judgment, held that if the subject or matter of dispute is not capable of settlement by arbitration under the law for the time being in force, such award is liable to be set aside. Supreme Court enumerated some of such non-arbitrable disputes and held that such action would be an action in rem and not in personam, and thus are not arbitrable. Then where there are allegations of fraud, also serious allegations, if the court feels that it cannot be decided in an arbitral process, but it would require more like a criminal process required, then certainly those disputes cannot be arbitrated. In fact, in Vidya, the court said that unless it is found that the dispute is not arbitrable, and if it requires further deeper consideration, the dispute with respect to the arbitrability should be left to the arbitrator to decide, considering the principle that the arbitrator is empowered to adjudicate on its own competence and jurisdiction to hear a dispute. Then whether the claims are time barred, that also was left to the arbitrators to decide in the Bharat Sanchar Nigam Limited versus Nortel Networks. Then comes the role of arbitrations, which Ms. Chiann now certainly mentioned. When it comes to role of arbitrations, I would, as Justice Khanna mentioned the other day, we would touch a little bit on maritime arbitrations. And the reason why I felt or Justice Khanna perhaps felt it required to be touched was explanation 3 in 7th schedule, which 7th schedule deals about the disqualification of, the ineligibility of arbitrators, but there it casts out an exception in explanation 3, which says, for the removal of doubts, it is clarified that it may be the practice in certain specific kinds of arbitration, such as maritime or commodities arbitration, to draw arbitrators from a small specialized pool. If in such fields it is a custom and practice for parties frequently to appoint the same arbitrator in different cases, this is a relevant fact to be taken into account while applying the rules set out in Schedule 7. So because that's, see, India has a very long coastline, and of late the GDP is expected to steadily rise, and India is the third largest economy in the world. The business side of the economy is also expected to increase exponentially. As in all business activities, there will be a large number of disputes which will need quick and efficient resolution. Typical disputes that arise in a maritime arbitration or in the maritime world would be related to charter party disputes and cargo claims. And most of these provide for English law and London arbitration. And that was because England has historically been in the forefront of maritime trade due to a robust common law legal system and experienced lawyers and arbitrators and other shipping experts. That's why we find arbitration clauses in contracts referring to London Maritime Arbitrators Association or LCI, London International Arbitration. But in India, of late, we have been seeing a lot of maritime arbitrations, and that's basically done under the ICA, Indian Council of Arbitration. And most of the contracts for charter party disputes involving public sector entities provide for arbitration by Indian Council of Arbitration. And I have had, as a lawyer, it's now 10 years, more than 10 years, experience where we have had experts who have been called to give evidence, particularly I can recollect very vividly a total loss claim of a ship which ran aground, and the owner lodged a claim for total loss. And the issue involved was whether she could have tried to ground. It was being taken for braking in Alang, whether she could have gone on her own power or the owner should have called for a tug to take her there. And we had experts giving evidence on the speed test of the ship. We had naval architects who were saying what will be the grounding effect when you take, we had master mariners coming in. So it's not that India is not capable of doing these kind of arbitrations. International arbitration, we should have institutional arbitrations for this, and they should have a robust panel of commercial men and master mariners or engineers who could take maritime arbitration, because it's a field which has not been explored much. Most of it happens in London. But with Singapore and Dubai particularly taking the lead in this kind of arbitration, I see no reason why India cannot take the lead. And we should have experts to that. And I should also mention that India is a friendly jurisdiction when it comes to arrest. And we have adopted the provisions of the 1999 Arrest Convention, and consequently arrests for the purpose of obtaining security either for the benefit of a foreign arbitration, or if no arbitration agreement, security in respect of suit claim is fairly straightforward. I must confess, I was the first judge to give security in a London arbitration with regard to a ship sale purchase. So we have a good option. We are running short of time, and I think I should stop here, and we'll leave everybody to raise questions.
Anybody who has any question or wants to make a statement, be a little short.
I'm a general manager from a public sector company. We have arbitration clause. It's a sole arbitrator. The name is given from the panel of Delhi International Arbitration Panel. So we give 3 names to the other party. These 3 names are taken in such a way that all those arbitrators were in the past, they have not decided any of our cases. Can the other side challenge this?
None of us would like to give legal advice. Thank you so much. It's a big change from adjudicating and authoring judgments, but invariably we make statements of law. It's nice to get some critical analysis of those statements of law. So this is my biggest input. I've got the biggest, attending this session. I must thank everybody, Madam Mulcahy, Chiann, Justice Shriram, and obviously all of you, you've been so attentive, and I hope you have also taken back something has been gained. It's a work in progress, it's not going to end. Arbitration in India is still developing, it's evolving, and hopefully next 5-7 years, there's going to be a big change. Thank you so much.
Hi, it's back. I'll go again. Thank you so much for such an interesting session. Maybe it's time to streamline the process, bring in maybe publication of awards in a redacted manner, collate data of appointments of arbitrators, to address some of the issues that we've discussed today. We'll now have a short break, 10 minutes, and we'll start the next session. Thank you.